So did you shoot your girlfriend and burn her house down?
Yeah, I did.
The defendant began punching her with his right fist, and he punched her 20 times.
In a case that shocked Virginia, Cola Winborn Beale IV embarked on a violent killing spree in March 2022, taking the lives of 3 people across Virginia Beach and Norfolk. From jail, Beale spoke openly about the crimes, providing chilling details and showing no remorse for his actions. The spree began on March 22, 2022, when Beale fatally shot his girlfriend, Xavier Hill, inside her Virginia Beach home.
I had the breaking point when her mom kept calling and she was crying like, so what is he gonna do? I shot in the head. So when I put the dog in the room, I was about to set the dog on fire. And she told me, she said, no, don't do nothing to the dog. You can take me and do whatever you wanna do to me instead and let him live. So I did that.
Overcome by anger, Beale claimed interference from Hill's family, and changes in her attitude led him to snap. 2 days later, he returned to the scene, burned the house to cover his track.
So did you shoot your girlfriend and burn her house down?
Yeah, I did.
He showed no remorse.
So you killed her Tuesday, set her house on fire on Thursday?
Exactly.
Do you have remorse for killing your girlfriend?
I mean, when you snap, you don't think about remorse.
Following this, Beale turned his attention to Clifton Baxter, a 73-year-old father figure, killing him as he slept on his couch because he didn't help him financially.
I found like $20,000.
Days later, on March 28th, Beale's cousin, Downing McLean, became his 3rd victim. Beale admitted he killed McLean to silence him, fearing his cousin would expose the earlier murders.
I got fed up with him because he kept talking like you not about this, you not gonna do nothing. Like, bro, I just people, you don't think I'm ready to shoot again? So I went right in the kitchen and shot him right in the head. He didn't drop, he just kept moving in circles. Then I shot him in the back to make sure he hit the ground.
After the killings, Beale fled to Hampton, taking his cousin's girlfriend hostage. Hiding in an Airbnb, he watched news reports of the manhunt.
So, I mean, I was definitely watching y'all broadcasts. I did some good broadcasts.
He later confessed that he was planning to kill more people before he was caught.
I was definitely looking for more people, but I was choosing my people wisely.
The spree ended on March 30th, 2022, when U.S. Marshals apprehended Beale.
Feel any remorse for
I don't feel no remorse about none of this at all. When you snap, you don't think about remorse. That's not something that comes to your mind when you're snapping.
His cold confessions shocked investigators and the public as he openly admitted to the murders and even advised others to check on their loved ones.
You just admitted to us to killing 3 people, and
Yep.
your advice to people at home is to go check on their loved ones?
Yes, because somebody checked on their loved ones, but they didn't know they was dead on Tuesday.
In March 2024, Beale was found guilty in Virginia Beach for the murders of Xavier Hill and Clifton Baxter. The charges included arson, abduction, and animal cruelty for setting Hill's home and her dog on fire. On July 2nd, 2024, he was sentenced to 3 life terms without the possibility of parole, along with an additional 62 years. In Norfolk, Beale faced trial for the murder of his cousin, Downing McLean. In May 2024, a jury convicted him of first-degree murders and firearm charges. By August 23rd, 2024, he received another life sentence plus 5 years. Chaos broke out in the courtroom as emotions ran high during the sentencing of Michael McGowan, the suspect in the shooting death of a girl, Giselle Rengifo. Tensions quickly escalated when police were called in to restore order, but the situation only grew more volatile. Cameras captured one officer grabbing a man by the neck, sparking further outrage as family members rushed to defend him. The commotion highlighted the raw pain and anger felt by the victims' loved ones as they believed the sentence was too lenient.
What justice? It's your court and there's no justice in here.
Cameras captured one officer grabbing a man by the neck, sparking further outrage as family members rushed to defend him. The family members defended.
Everybody saw that. Yes, because you. And it's all
The tragic incident occurred in May 2020 at a Miami house party, where McGowan, then 17, fatally shot Giselle Rengifo.
I was 17 at the time.
Throughout the proceedings, McGowan maintained that the shooting was accidental. In September 2022, he pleaded guilty to manslaughter. McGowan's attorney stated,
She weighed all the factors. This was a tragedy from the beginning, but it was an accidental shooting.
For Giselle's family, the sentence felt like a deep injustice. Overcome with grief, the girl's mother addressed the court, openly sharing the heartbreak of losing her daughter and the anguish of facing her killer. Their frustration echoed a belief that the punishment did not reflect the weight of their loss.
You're gonna call me mommy anymore. Mom, I love you, Mom. You took that from me.
So sorry, this is my fault.
The court sentenced McGowan to 364 days in jail, mitigated to time served, along with enrollment in a county boot camp program and 5 years of probation. As part of his probation, McGowan is also required to speak at local high schools to warn students about the deadly risks of mishandling firearms. A woman has come forward claiming she had a miscarriage after being attacked by 3 women who allegedly knew she was pregnant.
You're here to be arraigned on the charge of aggravated assault.
The incident happened on July 2nd after Delia Suggs reportedly warned the victim she was coming over to confront her. Minutes later, Suggs and Tenelly Luster arrived at the victim's home, and the situation escalated. According to the affidavit, the victim stated that these 2 suspects physically assaulted her, while a third person recorded the incident. The victim, who was 3 months pregnant at the time, later provided police with documentation showing she had a miscarriage 3 days after the incident.
A with a criminal attempt.
One of the suspects was seen smiling in her mugshot and reportedly displayed similar behavior in court.
If you're still here and they have to hire you a lawyer, I will give you a public defender.
Both Delia Suggs and Tenelly Luster have been arrested and charged with aggravated assault, a charge that could result in up to 15 years in prison and a $10,000 fine if they are convicted. A third suspect remains at large, with a warrant issued for her arrest. Tyler Terry's bond hearing offered a glimpse into his troubled state as his behavior in the courtroom raised serious concerns. Appearing disoriented and disconnected, Terry struggled to respond to the judge's repeated questions about his understanding of the charges and proceedings. The Chester County courtroom remained eerily still as Terry, often unresponsive and visibly detached, was asked to sign documents acknowledging his rights. His confusion and inability to maintain eye contact only added to the tense atmosphere.
Do you understand that? Do you understand everything I've been saying so far? I'm not quite sure you follow everything I'm saying. Sir?
Yes, sir.
Can you speak up?
Yes, sir.
Okay. Do you understand? Do you have any questions so far what we discussed?
No, sir.
Are you feeling okay?
Yes, sir.
The case dates back to May 2021, when Terry and his accomplice, Adrian Simpson, embarked on a deadly multi-state crime spree. The pair's crimes spanned South Carolina, Tennessee, and Missouri, leaving multiple victims in their wake. Among them were Simpson's husband, Eugene Simpson, in South Carolina, and Barbara Goodkin and Dr. Sergei Zakharev in Missouri. The spree extended into Tennessee, where other violent incidents were linked to the pair. After a dramatic high-speed chase and a week-long manhunt, Terry was captured in South Carolina. During subsequent court appearances, his detached demeanor and slow, inconsistent responses became a focal point, raising questions about his mental state. In November 2022, Terry and Simpson pleaded guilty to multiple murder charges in South Carolina, avoiding the death penalty in exchange for life sentences without parole. By July 2024, Terry also admitted guilt to the Missouri murders and received additional life sentences. Prosecutors across all states worked together to waive the death penalty, aiming to provide closure for the victims' families while avoiding lengthy and emotional appeals. Terry is now serving his life sentences in a South Carolina prison. His accomplice, Adrian Simpson, was also sentenced to life without parole for her role in the horrific crimes. investigators uncovered a case where an elderly Parma Heights man had his life savings stolen by 38-year-old Latasha Wisniewski, who befriended him under false pretenses. This case highlights the growing issue of financial exploitation of the elderly in Ohio, where many cases go unnoticed or unpunished. The evidence against Wisniewski was overwhelming.
These are serious charges. You're actually charged with police
Get
innocence.
out of my face.
We have some questions.
Why don't you ask daughter and the daughter?
Did you
Prosecutors revealed she systematically drained approximately $150,000 from the victims' accounts.
Just Botox. She was supposed to get dental done and maybe some butt shots. That's it. But I don't think some butt shots, but that's it.
I'm sorry, I don't understand.
Shots?
Shots.
Yes.
Where are those?
Like injections in your butt.
Testimony from key witness Lisa Dotson detailed how some of the stolen funds were used for cosmetic procedures, including Botox injections and butt enhancements.
This court finds that the state presented evidence that rises to the acceptable legal standard of guilty beyond a reasonable doubt.
Wisniewski appeared emotional in court, but declined to comment after her guilty verdict.
I'd like to know if you have anything to say after the guilty verdict,
Get
please.
out of my face.
Do you
That's
have
what I
anything
got
to say to your victims?
The victim's family, deeply impacted, expressed relief. His daughter shared.
This has been a long time coming, and she deserves everything that she gets here forward.
Former prosecutor Brent Kervil explained that Wisniewski left a clear trail of withdrawals and transfers that pointed directly to her theft.
Cash withdrawals, ATMs, counter withdrawals, but it was really corralling all the money into a checking account and then just pulling the drain plug.
On October 22, 2019, Wisniewski was sentenced to 3 years in prison for theft and money laundering. She was admitted to the Ohio Reformatory for Women on October 25, 2019, and released on August 7, 2022, after serving her sentence. Upon her release, Wisniewski began a 3-year supervision period under the Adult Parole Authority. Additionally, Lisa Dotson, Wisniewski's aunt, pleaded guilty to aggravated theft and money laundering in connection with similar crimes. She was sentenced to 18 months in prison in November 2019. Emmeline Nguyen, an 18-year-old from Thornton, Colorado, visited Dr. Jeffrey Kim's Greenwood Village Clinic on August 1st, 2019, for a routine breast augmentation surgery. During the procedure, Nguyen was administered anesthesia by nurse anesthetist Rex Meeker. Soon after, she suffered cardiac arrest and became unresponsive. Despite the life-threatening situation, Dr. Kim chose not to call 911 immediately. Instead, he attempted CPR but delayed seeking emergency medical assistance for nearly 5 hours. Staff members, including 2 nurses, reportedly urged Dr. Kim to call for help, but he refused. This critical delay resulted in Nguyen suffering severe brain damage. She remained in a coma for 14 months, unable to speak, walk, or care for herself, before tragically passing away in October 2020. The case sparked an extensive investigation, leading to charges being filed against both Dr. Kim and the anesthetist. Dr. Kim was arrested in February 2022 and initially faced serious charges, including aggravated assault and criminally negligent homicide. Rex Meeker, the nurse anesthetist, faced a manslaughter charge but avoided trial by surrendering his nursing license, resulting in the dismissal of his charges. Dr. Kim's trial concluded in June 2023, with the jury finding him guilty of attempted reckless manslaughter and obstruction of telephone service. However, he was acquitted of the more severe charge of negligent homicide. In November 2023, Dr. Kim was sentenced to 15 days in jail, followed by 2 years of supervised probation. He was also ordered to complete 120 hours of community service at a facility specializing in brain injury care and to pay a $50,000 fine. Shortly after, the Colorado Medical Board suspended his medical license. The Chula Vista Courthouse was filled with grief and anguish as the family of Megan Espinoza shared their heartbreaking loss. Megan, a 36-year-old teacher and mother of 2 boys, tragically died following a botched breast augmentation procedure in December 2018. Her family's tearful testimonies describe the void her death left in their lives, with her husband, Moises Espinoza, speaking through his tears. He declared that he can never heal from this.
I was robbed to say goodbye to her, robbed for the future. But I just want the court to know that this these individuals that robbed me from a future that I will never get again.
The tragedy began at Divino Plastic Surgery Center in Bonita, where Dr. Carlos John performed the procedure without a licensed anesthesiologist. Nurse Heather Voss, who lacked proper training, administered pain medication. During surgery, Megan went into cardiac arrest and began turning blue. Instead of calling for immediate help, witnesses testified that Dr. John ordered nurses not to call 911 and then left the room for 10 to 20 minutes to check on other patients.
And his nurse, who are responsible for callously ending Megan's life, have given her the death penalty. And they gave all of us who loved her a life sentence of extreme pain.
Prosecutors revealed that it wasn't until 3 hours later that Dr. John finally called for emergency assistance. Megan was rushed to the ICU but never regained consciousness. She remained unresponsive for 6 weeks and passed away, leaving behind her devastated family.
All of us together cannot fill the void that Megan's death has brought to them.
In July, Dr. Carlos John pleaded guilty to manslaughter.
If I could trade places with Megan, I would in an instant.
He was sentenced to 3 years in prison. As part of his plea deal, his medical license in the U.S. was permanently revoked. In court, Nurse Heather Voss tearfully apologized, saying,
"Words cannot express how deeply and truly sorry I am for my part in her untimely death."
Voss admitted to her role in Megan's death, pleaded guilty to involuntary manslaughter, and received a 2-year prison sentence. O'Neal Ron Morris, infamously known as the Butt Doctor, made headlines for years after performing illegal cosmetic procedures that led to the death of one of her patients. The case shed light on the dangers of unlicensed medical practices and left a lasting impact on victims and their families. The incident began in 2012 when Shatarka Newby, a woman Morris personally knew, sought cosmetic enhancements from her. Instead of using proper medical materials, Morris injected a dangerous mix of substances, including superglue and Fix-A-Flat, into Newby's body. The procedure caused severe complications, and Newby tragically died as a result. This was not Morris's first offense. She had previously served prison time in Miami-Dade County for practicing medicine without a license. However, Newby's death brought far greater scrutiny and outrage, leading to charges of manslaughter. At the sentencing hearing in Broward County, emotions ran high. Several victims who had also been subjected to dangerous procedures by Morris confronted her, expressing their anger and heartbreak. Morris, in her defense, described herself as a victim, claiming she had faced media scrutiny and discrimination as a transgender woman. Despite her claims, the judge issued a sentence of 10 years in prison, followed by 5 years of probation. Adding to the controversy, Morris, who is a pre-operative transgender woman, will serve her sentence in a men's prison, a decision her attorney argued places her safety at risk. Stephanie Sloop's case is a tragic story of a young boy's life cut short and the legal consequences that followed. It all began in 2010 when Ethan Stacy traveled to Layton, Utah to visit his mother, Stephanie Sloop, and her new husband, Nathan Sloop. What was supposed to be a summer visit turned into a heartbreaking series of events that led to Ethan's untimely death. Ethan had only been in Utah for a short time when signs of mistreatment began to emerge. Instead of caring for her son, Stephanie allowed abuse to escalate, eventually leading to Ethan suffering serious injuries. The situation worsened over several days, with Ethan experiencing neglect and physical harm. Rather than seeking medical attention, Stephanie and Nathan attempted to cover up the evidence of abuse, ignoring the clear signs of Ethan's deteriorating health. On May 10, 2010, authorities discovered Ethan's body buried near Powder Mountain in northern Utah. Investigators found that he had endured extensive injuries, and the cause of his death was linked to prolonged mistreatment. Both Stephanie and Nathan Sloop were arrested shortly after, facing serious charges related to Ethan's death. Stephanie was charged with first-degree felony aggravated murder and second-degree felony obstruction of justice. Nathan faced similar charges, including child abuse and desecration of a human body. During the investigation, Stephanie admitted that she had failed to protect her son and expressed remorse over her actions. She acknowledged struggling with addiction to prescription medication, which she claimed affected her judgment and ability to care for Ethan properly.
My selfish behavior is the reason I am standing here today pleading guilty to these charges.
Ethan is an innocent child, and I will carry his custody as long as I live. Like any burden, it's going to get heavier and heavier. The difference being I can't make it go away because it's part of who I am now. Ethan's death under these circumstances at times is too much to bear. But the fact is I am entirely responsible because I am his mommy. I failed to take care of him properly because I couldn't even take care of myself. My selfishness and failures as a parent caused Pumpkin's death, and there is no change in the fact that I am the one responsible. Aside from selfishness, my addiction to prescription medication and failure to get help paved the way for this. I failed to recognize the signs, or rather I just out and out ignored them, doing what I always wanted to do, like always. My selfishness wouldn't let me accept the fact that I had a problem, let alone let anyone else know. I am pleading guilty today because I am just that. I chose to abuse my medication to the point I was unable to make sound choices and decisions, thus causing to be reckless and indifferent with my baby's life. I was selfish when I brought Ethan into this world. I was selfish during his life, but I refused to be selfish in his death. I blame Nathan or Joe or anyone else. I have no one to blame but myself and my selfish behavior for Ethan's death. I have an obligation and a responsibility as his mother to take care of him and protect him, and I failed horribly. For the first time in Ethan's life, I was totally and completely irresponsible. And now I have not only caused his death, but I created a domino effect, a tragedy, and sadness for the remainder of Pumpkin's family. The selfishness I had always had took on a new form when it caused the baby's death. This time it affected more than me, and that's why it's completely and totally selfish. I love Ethan so much, and I don't know who I am without him anymore. I don't care if it takes the rest of my life. I will keep his chicken little smile alive and his Jerry Maguire cuteness alive, and make sure the world knows why my little boy's life mattered. Joe, I'm sorry for you, for the kids, for everybody. I'm sorry. And I'm sorry to Layton PD and the prosecutor's office and everyone for all of this circus. It shouldn't have gone this far.
In court, Stephanie eventually pleaded guilty, admitting her responsibility and expressing regret for the pain she caused. She stated that her selfishness and inability to care for herself ultimately led to her son's tragic fate.
Ms. Sloop, having been convicted of the offense of aggravated murder, a first-degree felony, you are sentenced to an indeterminate prison term of 20 years to life in the Utah State Prison. Having been convicted of the offense of obstruction of justice, a second-degree felony, you are sentenced to a term of 1 to 15 years in the Utah State Prison. The court orders the sentences to be served concurrently, and that Ms. Sloop will receive credit for time already served.
During sentencing, Stephanie was given 20 years to life in prison for aggravated murder and an additional 1 to 15 years for obstruction of justice. The sentences were ordered to run concurrently, with the possibility of parole after serving a minimum of 20 years. The judge emphasized the gravity of the crime, acknowledging the pain suffered by Ethan and the lasting impact on his family. Stephanie's sentencing meant she would not be eligible for parole until 2055, when she would be 72 years old. Prosecutors urged the parole board to deny any potential release, citing the severity of the case and the irreversible harm caused. Nathan Sloop, Stephanie's husband, and Ethan's stepfather, also convicted in connection with Ethan's death, is serving a 25 years to life sentence. His first parole hearing is likewise set for May 2055. Born on August 26, 1967, in Shaker Heights, Ohio, Lance Mason pursued a successful career in law and public service. After earning a law degree from the University of Michigan in 1992, he worked as an assistant prosecuting attorney and later served as an aide to U.S. Representative Stephanie Tubbs Jones. His political journey began in 2002 when he was elected to the Ohio House of Representatives, eventually moving to the Ohio Senate in 2007. In 2008, his career reached new heights when he was appointed as a judge on the Cuyahoga County Court of Common Pleas. Despite his achievements, Mason's personal life faced significant challenges. On August 2, 2014, an argument with his wife, Aisha Fraser, while driving home from a family event, escalated into a physical altercation. The situation became serious enough to warrant police involvement, leading to Mason's arrest. A subsequent search of his home uncovered a collection of firearms and other equipment, which raised further concerns about his actions.
Shaker Heights officers responded to Hillcrest Hospital to speak with the victim, Aisha Mason. The victim stated they were driving back from a funeral and the defendant began to argue about their marriage. Their two daughters were in the back seat of the vehicle. The defendant was driving and he was in the front and she was in the front passenger seat. The defendant began punching her with his right fist in the head while driving. She stated it was a closed fist and he punched her approximately 20 times. After punching her, the defendant grabbed her hair on the back of her head, smashed it against the center console approximately 5 times. The victim stated as he was beating her, she continuously pressed on the vehicle's horn, hoping to get somebody's attention to help her. The victim then stated that the defendant began to choke her, but was unable to do so. He used his arm to pin her head and neck against the passenger door window. The two children were in the back seat of the vehicle screaming and crying. That's probably, in addition to the terrible, savage beating that you gave your wife, the fact that your children are in the back witnessing this, screaming and crying, exposing your children to this kind of violence is really unbelievable. The vehicle came to a stop at the red light and the victim attempted to get out. The defendant grabbed her by her hair and would not let go. The victim was able to escape his grasp and exited the vehicle and onto the street. The defendant then crawled over the center console and the passenger seat, exiting the vehicle on the street and got on top of the victim. The defendant continued to punch the victim in the face 3 or 4 more times, bit her on her right ear, stating, "Your life is over now." The defendant then got back into the vehicle and drove away. The victim then got up, ran down the street. She came across some Samaritans who helped her.
In 2015, Mason pleaded guilty to charges of attempted felonious assault and domestic violence. In court, Mason admitted to his actions and expressed deep remorse. He acknowledged that he had physically assaulted his wife in the presence of their daughters, causing harm not only to her, but to his entire family. Mason took full responsibility for his behavior, emphasizing that he had no excuses for his actions.
Good morning, Your Honor. You know, I'm humbled by the comments of so many people. I can't promise that I won't be emotional, but it's not to curry sympathy. I'm here to be punished today for what I did to my wife and my children. I take the crimes I committed against my wife and my children. I have no excuses. I beat my wife in front of my kids and put them in harm. And I am solely responsible. And nothing justifies the harm I've done to my wife and my family. There hasn't been a day that I have not regretted my actions. I was raised to be stoic, especially by my mom and the actions of my dad during challenging circumstances. But in private, there have been many nights on my knees, and I've mourned the harm I've done to my family. I mean, I'm heartbroken and devastated for the pain I caused my wife and the girls, but it doesn't compare to the pain and devastation that I've done to them. And I can't undo that harm or undo what my girls witnessed, and it tears me apart. I struggle to understand my actions. I didn't know I was capable of doing this. I mean, I even bit my wife. I mean, that morning I prayed for my wife and children. I wasn't even going to pick them up for the funeral. And I just went and picked them up because we were sharing a car. But all of my life I fought against this type of brutality that I did to Aisha. When I became a judge, I wanted to be a judge at some point in my life, but I thought it would be 20 years later because I thought I was too young and didn't have enough experience. What happened was a crisis in my home, and so I sought to come home to continue to serve the public, but to take care of my parents, my father who had dementia, my mom who had a near fatal heart attack, and also suffered dementia. And I came home to help my wife because our daughter had just been born with special needs. And I didn't realize that I was this broken. I mean, I had no idea. I blame my wife, but I was broken. I've done everything I know to do to understand why I hurt my wife and children and jeopardize the lives of what I value most, Ava and Audrey. I will continue to do whatever is needed to ensure nothing like this happens again. As people know that I've sought as much treatment as everything I knew to do. I joined 3 groups in church. I've longed to apologize to my wife and her family. Prior to the plea offer, I told my baby Ava that I told her that I was wrong for hitting her mom and that I was sorry. I failed the public. I failed my wife and my family. I failed my girls, who I've tried to be a good example to and to protect every way I could. I'm probably overprotective. And because of my action, I realized that I've left my wife to raise our daughters alone, to provide for them alone, and it's against everything I've learned and everything I know, and I sincerely regret it. My prayer is that in the future I live a life that will make it possible for Aisha, Audrey, Ava, and all that I've hurt to forgive me. And I'm ready to be punished.
During sentencing, court reviewed evidence from the police report and victim impact statement, which highlighted the physical and emotional scars left on Mason's wife. She suffered severe injuries, while also experiencing long-term psychological trauma.
Either a sick child, or you lose your husband, or you lose your wife, or you lose a child, or your financial problems. But you don't take it on other human beings. Now, I'm looking at these pictures here of Aisha. They're horrible. This one here shows not only her eyes are swollen shut, she's got a bite mark on her cheek. You bit her. You weren't satisfied to beat her, you bit her. Her eyes are swollen shut to the point her orbital bone is broken. And I'm not going to go through the multiple bruises on here. And in fashioning a sentence, the court also has to consider not only the physical harm that you caused her, but also the psychological harm as well. In the pre-sentence investigation, the court ordered a victim impact statement. And this is what Mrs. Mason said. I'm going to reference a portion of it. The incident of 2nd, 2014 have changed my life forever. My children have post-traumatic stress disorder resulting in physically abusing Mrs. Mason. I also suffer from the physical scars of having my orbital bone broken. In fact, I currently do not have any feeling in the left side of my face due to nerve damage. I also suffered mental and emotional for many years during my marriage, and my daughters will forever be impacted by the loss of their father in their lives during this period.
The victim's statement detailed how the incident had permanently affected her life and the well-being of their daughters.
Deter others. If you don't receive punishment and you're a judge for the same crime that somebody else standing in front of me would be punished for, there is no rule of law in our court. I've considered the minimum sentence, however, the court feels based on the brutality of the attack and the other seriousness factors in section 292912, to give you the minimum sentence would demean the seriousness of the offense and not adequately protect society from future criminal conduct by yourself and others. I've considered the serious physical and mental and economic harm to the victim, that the offender's reputation or occupation is likely to influence others' conduct. Certainly the relationship in this case facilitated the offense. And as I said, perhaps most important, this domestic assault case was done in the presence of your children. In reference to this case, after considering what has been said here today, the pre-sentence investigation, the victim impact statement, the defendant's statement here today, the sentencing brief, and all the letters, in reference to the charge of attempted felonious assault, the court is going to impose a prison sentence of 24 months. I'm going to impose 3 years of mandatory post-release control. As you know, but I will tell you again, upon your release from prison, the Adult Parole Authority will monitor you on post-release control for 3 years. During that time period, if you violate any of their conditions, the Parole Authority can impose additional sanctions, including additional incarceration in prison that would equal to 1/2 of this court's given prison term. And they can do so in increments for repeated violations. It's also possible to reduce your sentence by participating in certain educational, vocational classes while incarcerated. That credit can also, extra credit can be taken away from this behavior while incarcerated in prison.
Mason was sentenced to 24 months in prison for attempted felonious assault, with an additional 6 months for domestic violence to be served concurrently. He was also placed on mandatory post-release control for 3 years following his prison term. The judge encouraged Mason to take advantage of counseling programs while incarcerated, including anger management and domestic violence intervention programs, to address his underlying issues and prevent future incidents. He was sentenced to 2 years in prison, but was released early after serving 9 months. Following his release, he faced professional repercussions, including the indefinite suspension of his law license and resignation from his judicial position. Despite his legal troubles, Mason found employment in 2017 as a minority business administrator for the city of Cleveland. The hiring decision drew criticism given his past legal issues, but he appeared to be attempting to rebuild his life and career. However, the past resurfaced in a devastating way. Tragedy struck again on November 17, 2018. During a visitation exchange at a home in Shaker Heights, Mason fatally attacked Aisha Fraser in the presence of their daughters. The community was left reeling from the loss of Fraser, a beloved 6th grade teacher known for her kindness and dedication. Mason fled the scene in Fraser's vehicle, but was quickly apprehended after crashing into a police cruiser, injuring an officer.
The maximum sentence the state requests. However, if there is something, anything positive to transpire out of this in the future, is for you to make a difference while you are in prison, to help others with your background, to demonstrate a servant attitude. It is for that reason only that after you serve the 5 years for Officer Flint and 30 years for the aggravated murder as part of a life sentence, you will then be eligible to appear before a parole board. I am hopeful that during that period of time, with that glimmer of hope, that you will take advantage of that and you will, in fact, make a difference in the lives of those people around you. In summary, the court sentences you to life in prison with parole eligibility in 30 years and 5 years for the felonious assault of Officer Flint. Those sentences to be served consecutively, and as indicated with regard to the felonious assault, should you be released from prison, there'd be a mandatory period of incarceration of 5 years, and any violations of that supervision would lead to periods of re-imprisonment. Anything further to come before the court?
Nothing, Your Honor. Thank you.
No, Judge. No, thank you, Your Honor.
In August 2019, Mason pleaded guilty to multiple charges, including aggravated murder, murder, and violating a protection order. On September 12, 2019, he was sentenced to life in prison with the possibility of parole after 35 years. Aisha Fraser's passing deeply affected her community. As a dedicated educator and loving mother, she left a lasting impression on those who knew her. In response to the tragedy, efforts were made to strengthen laws aimed at preventing similar incidents, including the introduction of Aisha's Law, which seeks to provide better protection for individuals facing domestic challenges. Jessica Howes, a concerned mother from Elyria, Ohio, found herself at the center of legal proceedings following an incident at Hamilton Elementary School in April 2023. Frustrated over what she believed was the school's failure to address ongoing bullying involving her son, she attempted to enter the building through an unauthorized door. Assistant Principal Katie Huff, who was 7 months pregnant, tried to intervene. A heated exchange followed, during which Principal Joel Melvin stepped in to de-escalate the situation. In a moment of tension, Howes used a small canister of mace attached to her keychain and sprayed Melvin. The school immediately implemented a modified lockdown to ensure safety. Later that day, Howes voluntarily turned herself in to the Elyria Police Department.
Case number 2023 CRA 01186, State of Ohio, City of Elyria versus Jessica Howes. Defendant was charged with 2 counts of assault, 1 4th-degree felony, 1 5th-degree felony. Also, case number 2023 CRB 01187, State of Ohio, City of Elyria versus Jessica Howes. Defendant was charged with criminal trespass, misdemeanor 4. These matters were set for preliminary hearing today, Your Honor.
She was charged with 2 counts of felonious assault, one classified as a 5th-degree felony and the other as a 4th-degree felony, along with a charge of criminal trespassing. Authorities took the incident seriously, emphasizing the need to maintain a safe environment within schools.
All right, so Ms. Howes, I'm going to continue the bond that I set at your initial appearance, at your initial appearance, and the same conditions are going to apply. You can have no contact with either Joel Melvin or Katie Huff. That means you can't have any contact with them, either face-to-face or through any aid or device. You cannot call them, text message, email message, Facebook message. No contact whatsoever. You can't have anybody else have contact with them on your behalf. If one of them is somewhere and you arrive, even if you didn't know that they were going to be there, you have to leave. If you are somewhere first and one of them arrives, even if you didn't know that they were coming, you're the one that has to leave, and they can't give you permission to have contact with them. So even if they were to say it's okay, it's not okay. You understand that? Now, I can't keep you off Facebook, but I can tell you, you cannot have any contact with them through Facebook. You understand that? I'm sure that Ms. Robinson has already given you some very wise advice about that. I would suggest that you follow that advice. You understand all that? All right, also, you have to stay at least 500 feet away from any Elyria City school facility. Do you understand that? All right. All right, so Ms. Howes, you've also been served with protection orders in this case, is that right?
Correct.
So the protection order applies to Katie Huff and Joel Melvin. And it does indicate that you have to stay at least 1,000 feet from any of the protected persons, all right? But it is 500 feet away from any Elyria City school property. But if they are at school, that means you have to stay at least 1,000 feet away from them. So regular school hours, I would suggest you stay away. Make sure you stay at least 1,000 feet away. You understand?
She was released on a $25,000 bond with strict conditions, including staying at least 1,000 feet away from Principal Melvin and Assistant Principal Huff, as well as maintaining a distance of 500 feet from any Elyria City school property. The court also prohibited her from discussing the case on social media or engaging with anyone involved.
Your Honor, my client would withdraw her formal entered plea of not guilty and request for a jury trial. She would be, entering a guilty plea to the amended indictment to the 2 counts of felony violent assault.
All right.
Ms. House, you've been very patient this morning. You've heard everything that we've discussed. Is this what you want to do today? Do me a favor, bring the microphone closer to you so I can hear you and the record can hear you, please. Yes. You understand that you do have a right to a jury trial, and we have jurors prepared to proceed if you wish to exercise your right to trial. You understand that? Yes. You've had a chance to talk to your attorney about this situation and go over your rights on the plea sheet. Is that correct?
Correct.
And I'm going to ask you one more time. Is this what you want to do today?
Yes.
All right. I'm going to ask you a series of questions to make sure that you understand what's going on and to confirm that, in fact, this is what you want to do. If at any time I ask you a question you don't understand, ask me to explain it further. And at any time if you want to take a break and consult with Ms. Robinson confidentially, let me know that. And I'll stop these proceedings so that you can talk to her, okay?
Yes.
You need to answer out loud, and you can answer my questions yes or no. Are you a U.S. citizen?
Yes.
Do you read and write the English language?
Yes.
Do you understand that your attorney has asked me to withdraw your previously entered plea of not guilty and enter a plea of guilty to an amended indictment which consists now of 2 felonies of the 5th degree assault, the criminal trespass, the misdemeanor will be dismissed upon me accepting a plea and finding you guilty. Do you understand that?
Yes.
Do you understand that those 2 charges, those felony 5s, each carry 6 to 12 months in prison in monthly increments and up to $2,500 in fines? So the maximum possible penalty in this case would be 2 years in prison and $5,000 in fines. Do you understand that?
Yes, I do.
Do you understand the nature of these 2 charges and the factual basis for these charges?
Yes.
Based upon the maximum penalties I just went over with you, in consideration of that, how do you plead to these 2 charges?
Guilty.
Has anybody threatened you in order to get you to plead guilty?
Yeah.
Other than what you've heard discussed in the courtroom, has anybody promised you anything in order to get you to plead guilty? I believe the only representations that I have made to you are that I will continue you on bond and I will give you a pre-sentence report. Has anybody promised you anything else in order to get you to plead guilty today?
Well, he said no jail time. No, he had.
No, I did not.
He had indicated he would defer to the court for sentencing.
That's correct.
To the prosecutor.
You could get up to 6 months in county, 6 months in county jail. You could go to the CBCF, which is up to 6 months. So the worst case scenario, I want to repeat again, is 2 years in Marysville prison for women. That is a possibility. It's on the table. It's also a possibility you could get community control, which is like probation.
Months later, in February 2024, Howes appeared in court and pleaded guilty to the assault charges in exchange for the dismissal of the trespassing charge. During the proceedings, she expressed deep regret, stating that her actions did not reflect the kind of mother she wanted to be. She acknowledged that frustration over her son's situation led to a poor decision and assured the court of her commitment to making better choices in the future.
Obviously, a parent, I can understand a parent protecting his or her child, of course. But if you think about the irony of what happened, you essentially assaulted and bullied 2 people in response to your son being mistreated. I mean, how is that the way to advocate and protect your son and go to bat for him? By doing essentially the thing he was being subjected to other people.
In March 2024, Judge Chris Cook sentenced Howes to 24 months of community control, requiring her to serve the first 6 months in the Lorain County Jail. The judge stressed the importance of maintaining order in educational environments and highlighted that such incidents, regardless of intent, have serious consequences. He noted that while concerns about bullying are valid, addressing them through inappropriate means cannot be condoned. On January 22, 2010, Daniel Kover-Basich from North Ridgeville, Ohio, was dropped off at the home of 55-year-old family friend Dwayne Hurley. Hurley had offered to drive him to school, but the visit took a tragic turn when Daniel striked and stabbed him to death. The community was shocked by the incident, and Daniel was soon taken into custody, facing serious charges, including 2 counts of murder and felonious assault. As the case unfolded, troubling details about Daniel's past experiences with Hurley began to emerge.
Do you understand what's going on today? Yes. What is your opinion of what's going on? Do you understand that we're waiving probable cause today? It's not an admission of guilt, or are you waiving any right to have a trial in this matter? Do you understand that? Yes. nor are you waiving any right to claim any defense or have any witnesses testify against you as far as cross-examination or to call your own witnesses. Do you understand that? Yes. It's merely indicating that at the time of the offense, you were 16 years of age or older. Is that correct? Yes. And how old are you now? 16. And when was your birthday?
October 23rd, 1993.
So you were 16 at the time of the alleged offense, correct? Yes. It's also indicating that you were charged with what's called a Category 1 offense. Under the Ohio Revised Code, that would be a charge of murder. Do you understand that? Yes. Do you understand the charges that you have, in fact, been charged with? 2 counts of murder, 2 counts of felonious assault? Yes. Furthermore, there's a stipulation that Lorraine County is the proper venue, and a stipulation that there is probable cause to bind us over. Do you understand that?
During legal proceedings, it was revealed that Hurley had been a close figure in Daniel's life for several years. Initially seen as a trusted family friend, Hurley had built a relationship with Daniel and his family. However, Daniel later disclosed that Hurley had been abusing him since he was 12 years old. The relationship had started with gifts and attention, gradually turning into a cycle of control and manipulation. Over the years, the pressure and fear Daniel felt continued to build, leading to the events of that morning. Investigators also found thousands of images stored on the device, many of which depicted inappropriate content involving boys and girls.
Officer Ryan Young got on the stand and relayed some of the conversation he had with Kovacevich's brother Greg while waiting several hours for a search warrant to be obtained from Cleveland.
Sure, he said acting weird?
He definitely said acting weird.
Witness attorney, Dylann, you may not be.
Okay, thank you, Ron. Okay, go ahead. What else did you talk about?
Well, I asked him what he meant by what do you mean he's acting weird, and he really didn't give a great description of this weird behavior. He said he's just a weird guy. I said, okay, we just continued on. I was there for a long time, a number of hours, and it wasn't shortly after our initial conversation about Dwayne, the statement of him being weird, maybe about 10 minutes later, 15, I can't say for sure, but a short time later he said, he brought up, Dwayne said he touched his brother, Daniel, and I asked him to explain that. He said,
go ahead, I'm sorry.
Oh, and he said, well, I know.
I acknowledge that this is all hearsay, Attorney Bradley, but I'm sort of interested, so I'm going to hold you a little bit.
Thank you.
I'll give it whatever weight I think is appropriate. Attorney Kim.
Okay, go ahead, Officer.
I asked him to explain, talking to Gregory, what he meant by he touched his brother, and he said, well, I know that he's touched him before. So, I was curious about that, and Gregory followed by saying that Dwayne even asked him if he would like to make a porno with him, and that meaning Gregory. And I remember I immediately asked, I said, well, have you ever talked about this with your parents? Have you ever told them about, touching your brother or what he said about you making a porno? And he said, I told my parents that he was a weird guy, but I never told them that about the porno.
The second half of the afternoon was spent looking into evidence recovered from Hurley's computer, including examples of the thousands of images stored on the computer, including pictures that appeared to be underage boys participating in graphic sexual acts.
After his arrest, the case was moved to adult court due to the severity of the charges. Daniel's defense argued that he had been suffering from prolonged trauma and that his actions were a reaction to years of abuse.
Mr. Kovacevic has no history of violent offenses. And the second purpose of bond is to make sure that he's going to appear at all future court proceedings. As we discussed a couple of weeks ago when we were here last time, despite the state's representation that Mr. Kovacevic was unavailable, because the state doesn't know where he's at, doesn't mean he's unavailable. He was at his uncle's house in Avon Lake. Within an hour of being asked where he was at, I voluntarily turned him into North Ridgeville Police Department. Mr. Kovacevic had no problem going. He understands that there's a process to this whole thing. This isn't going to be over anytime soon. But at 16 years old, charged with the murder, he said, I'm not going anywhere. Let's defend this thing. And I think that he should be given some credit and consideration for that. The majority of the people in the courtroom here, to my understanding, are people that are here in support of Mr. Kovacevic. He's got a pretty decent network of family and friends that are willing to help him, assist him, make sure he's sticking around. I've had the opportunity to get a report from the detention home where he's been for the past couple of weeks. They said he's doing great. He's completing all of his homework, completing all of his assignments on time. He's been polite, cooperative. This kid isn't a problem kid. And I think that, keeping him in custody only is going to ensure that he doesn't get out. And if he doesn't get out, means that schoolwork's interrupted. He's going to be unable to assist me in his own defense as well as I would like him to be able to. I don't think that there's a sufficient justification for an extremely high bond in this case. His family is of limited resources. I know the state is going to request a very high bond because that's what the state does. I don't know that they have any insight into, Mr. Kovarbasich's personality that I myself don't have. And I think that I would ask for his release on a personal bond with his parents.
His defense attorney emphasized that he had no prior history of violent offenses and was willing to face the charges responsibly. They also highlighted his cooperation with authorities, pointing out that he had voluntarily turned himself in to the North Ridgeville Police Department after staying at his uncle's house in Avon Lake. Despite the gravity of the charges, Kovarbasich had a strong support system of family and friends who attended the hearing to show their support. Reports from the detention center indicated that he was compliant, polite, and engaged in his school work while in custody.
Several factors, as both counsel know, one of which is the nature of the charge, and one of which is what's high enough amount or low enough amount to guarantee that the defendant in this matter will in fact appear for court in his family background situation. I will note the limited amount of information that I have in this matter, and certainly bond can be taken up at any time in proceeding, especially once it's found over. And then the new judge has that, whoever that judge may be. So at this set time, I'm going to set the bond at $500,000 cash assured.
Despite this, the prosecution maintained that the violent nature of the incident warranted serious legal consequences. The judge set bond at $500,000 cash or surety. In April 2010, Judge James Burge found Daniel guilty of voluntary manslaughter and aggravated assault, acknowledging the complexities of the situation, but stressing the need for accountability.
I would agree with the state of Ohio that Daniel's story did change. It varied. It went from self-defense to no defense at all. But I don't find that change in the account is due to his calculating personality or intellect. The psychological report, mental status report that was conducted before this matter was bound over to the adult system indicated that, although not mentally ill, Daniel was very low functioning at the time this offense was committed. I hope that the conclusion is that the low functioning was due to a lack of interest rather than a lack of intellect. Therefore, it will be the judgment of law and sentence of the court that this defendant serve a community control sanction with a term of 5 years, which will expire on August 12, 2015. Before completing this community control sanction, the defendant will receive a high school education and a driver's license. He will be under intensive supervision for a period of 5 years. He will remain incarcerated until admitted to a program of rehabilitation selected by the court. That being said, deputies, you may take control of Mr. Kovarbasich for and we are adjourned.
In August 2010, Daniel was sentenced to 5 years of probation with specific conditions, including completing his high school education and obtaining a driver's license. The court recognized the impact of the abuse he endured and decided against a lengthy prison sentence, opting for a period of supervision and rehabilitation instead. Before being released, Daniel spent 16 months in the Lorain County Jail as arrangements were made for his transition. Eventually, he was placed under house arrest at his parents' home in in May 2011, monitored by a GPS device and permitted to leave only under specific conditions. The court struggled to find a suitable rehabilitation facility willing to accept him due to the nature of his case. The case gained national attention, drawing interest from various media outlets. Daniel and his family appeared on the Oprah Winfrey Show, where they discussed their experience in the hope of raising awareness about grooming and the long-term effects of abuse. They shared their story to educate others on recognizing the warning signs and seeking help before situations escalate. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.